जी जी जी।
Mm, Good evening, everyone. I hope you all are safe and healthy and are taking the protection uh, to save yourself from this grim condition. So, our today's discussion is based on basic structure of the Constitution, the judgments we are going to discuss today. Our Constitution has 22 parts which includes 395 articles. And in beginning, it was having 8 schedules. As of now, it has 12 schedules. These 22 parts contains part 3 is related to fundamental rights, which starts with Article 12 to Article 35, while part 4 is related with directive principle of state policies, starting from Article 36 to 51A, as well as we are going to discuss this part 20, where at Article 368 is there, which is the main article related to the provisions of amendment to the Constitution. So, as we are aware that part 3, which relates with fundamental rights, uh, these are protected by the Constitution itself, which cannot be violated. While part 4, which is directive principle of state policies, wherein states are entitled to make any law which promotes equality between the citizens and to secure and promote social welfare, as well as equal distribution of the assets. Actually, Pandit Nehru firmly believed that socialism was the uh, economic model most suited to the India. Socialism is a political belief which says that all should be equal. There should be equal distribution of assets between the public. As after independence, there was a lot of discrimination. Uh, there were rich and poor, and a dream was saw by the public as well as the politicians to develop the country, and for completing and achieving that dream, it was required that land some reforms which were very aggressive should be made, so that directive principles of state policies should be achieved. So in that view, the after immediately after independence, states started making law to give effect to those directive principle of state policies which are enshrined in part 4 of the Constitution. And to achieve those objects which are mentioned therein, they started making laws which were agrarian law reforms, as well as they were providing reservation in education to the economical and socially backward class. The land reforms which were introduced were sort of whereby sealing of lands were introduced. uh, for suppose if a person was having 2000 acres of land, and government came out with a scheme that he will only keep 100 acres of land and remaining 1900 will be acquired by the government. This was for the purpose of giving effect to directive principle of state policies. But in a way, when you give effect to the directive principle of state policies by taking over land of one person, so in other way, it takes away fundamental rights, which is right to equality and right to freedom 19(1)(f), whereby it says that every citizen, a person has a right to hold and acquire property, as well as uh, under Article 31 also, which was previously it was right to property, which is now omitted. Therefore, when these reforms were introduced and those persons who were affected by those reforms, they challenged those reforms by filing writ petition before the high courts. In few of the cases, the high court confirmed those reforms which were introduced by the state government, while few high courts struck down those laws on the ground that these are violative of fundamental rights. The Article 37 of the Constitution, which provides that directive principle of state policies are not enforceable by the court of law. Article 39, Article 38 and 39 B and C are important for today's section, as today's session, as well as Article 14, 15, 19 and 31, which are fundamental rights and under Part 3rd. So the persons whose rights were affected by those reforms which were brought by the state government, they challenged, and some high court struck down those laws and some confirmed those laws. Therefore, uh, it was felt by the government that as their dream is some way in, going behind, and to promote or not to get affected by those high court judgments which were striking of those laws, they came out with first amendment of the constitution. As at that time Congress government was in central and more than 90% states were under the where Congress party was ruling. So they amended the constitution. It was not a tough task for them. By way of introducing first amendment to the constitution, they introduced Article 15(4) and Article 31A and 31B. 15(4) was to protect the laws which were introduced for promoting the social economical backward class, as well as laws made for promotion for the promoting scheduled caste and scheduled tribe, while Article 31A was law which gave power to the government to acquire any property or any land, or to acquire the companies, whatever the needs they were having to promote the social welfare of the public. Article 31B was also introduced, whereby this Schedule 9 was introduced, in which if any act made by central government or state government, if once inserted in that schedule, that will be immune by the judicial review. So that law could not be challenged in any court of law. When these amendments were brought in or introduced, thereafter this first amendment of the constitution was challenged by Shankari Prasad Dev. The matter went to the five judges bench, as the matter related to the interpretation of the constitution, which is so it should have gone to it went to five judges bench, which is as per the requirement of Article 145. The Supreme Court, with full majority, held that uh, Parliament has unlimited power to amend the Constitution, and the constitutional amendment law does not fall under the definition of under Article 13(2), which says that any law which is inconsistent with the fundamental rights or Part 3rd shall be void to that extent. So they said that constitutional amendment law will not fall under that Article 13(2). Thereafter, after 2 years, after 15 years, again these section 368 and 13(2) were this in the case of Sajjan Singh's, again these were challenged before the Supreme Court, that that Parliament has no power to amend the Constitution, And there were various reforms were made in between from the first amendment till the judgment of Sajjan Singh's case. It was 17th constitutional amendment which was challenged by Sajjan Singh. Now this time again matter went to 5 judges bench, but now there was difference. The judgment uphold the Shankari Prasad Dev case, but there was dissent of 2 judges, Justice Hidayatullah and Justice Mudholkar. They gave concept of basic structure of the constitution, and they gave an idea that there are certain implied limitations on the power of the parliament to amend the constitution. Thereafter, state of Punjab, as all the states were introducing agrarian law reforms, now state of Punjab came out with law reforms whereby some ceiling limit was put, and land of Golaknath was acquired by the state government. So I.G. Golaknath challenged under that acquisition by way of filing writ petition under Article 32 in the before the Supreme Court. Now this matter went to 11 judges bench because they challenged first amendment to the constitution as well as 17th amendment to the constitution, and there was a dissenting view in case of Sajjan Singh's. So this matter went to 11 judges bench. Now in this case of I.G. Golaknath, the majority, the judgment came with a majority of 6:5, whereby it was held that the constituent power is limited and parliament don't have unlimited power to amend the constitution, and constitutional amendment law fall under the definition of article of fall under the definition of law which is given under Article 13(2). Justice Subbarao first time invoked a doctrine of prospective overruling, whereby the effect of judgment was on the future laws which should be made by the parliament. The previous laws which were made were not to be affected by this judgment of I.G. Golaknath. Thereafter, in 1969, the Indira Gandhi government was in power, so they came with a policy of nationalization, wherein all banks in India were nationalized by way of introducing an ordinance. This ordinance was struck down on the ground that the compensation, the amount of compensation which was to be decided or to be paid to the persons who against the acquisition of bank assets and properties, that this was not just, fair, and reasonable. Now, again, the Indira Gandhi government came with the abolition of privy purses by way of promulgating an ordinance whereby while at the time of independence there were some princely states, so those princely states were merged the in India on a condition that they were promised by putting an article in Constitution of India that they will be paid some annual charges or annual amount for maintaining their lifestyle and maintaining the expenses which they were having to have that lifestyle of prince as a prince. So it was on the basis that so much of the amount is used to be paid to those rich persons, while this amount can be utilized for the general public. So on that ground, the Congress government came with an ordinance whereby they struck down and said that no privy purses should be paid to the princely states under Article 291 and 362. Again, this was challenged by Madhavji Rao Jivaji Rao Scindia, and this ordinance was struck down. As there were elections due in the year 1971, and Indira Gandhi won with a thumping majority by winning 352 seats out of 518. So, after coming into power, immediately she introduced many constitutional amendments, laws which were to overrule or to uh, uh, come out from the effect which was made by way of the judgment given pronounced by Supreme Court in Golaknath's case. So this 24th amendment to the Constitution was to overrule the judgment in Golaknath's case. Then 25th constitutional amendment was to overrule the bank nationalization case. 26th constitutional amendment was to overrule the privy purses case. And 29th constitutional amendment law was introduced, whereby certain Kerala law reforms, uh, Kerala Land Reforms Acts were introduced, and these Kerala Land Reforms Act were inserted in ninth schedule, so making them immune from any challenge before the court of law. Now, when this was the position, uh, the His Holiness Keshavanand Bharati was a Mathadish in a Math at Kerala, whose the land of Math was also acquired by the state government. So they challenged those amendments uh, by way of filing writ petition under Article 32. The matter went to the largest bench of 13 judges, and the cases which were argued, and I would like to tell you that all these cases wherein this Golaknath case as well as bank nationalization case and privy purchase case was argued by Mr. Nani A. Palkhiwala, and he won all the cases. Thereafter, this Keshanand Bharti was also argued by Mr. Nani A. Palkhiwala. So it is said that he saved the constitution and democracy in India. Now, when this case was argued, Keshanand Bharti, the arguments which were made by uh, the petitioner side was that there should be some implied, there are some implied limitations on the amending power of the constitution, as our constitution uh, is sovereign and democratic, social, uh, having social structure. Therefore, these are the basic things which cannot be destroyed or which cannot be altered. The examples which were put on before the Honorable Supreme Court were like that: if suppose a government come with a thumping majority, and thereafter they decide that now they are in power, so now there is no need for any further election, so they all for whole life they will be in power. So can it be done if the unlimited power is given to the parliament? Next was if the our constitution provides that a person of certain age, earlier it was 21 years, which is now reduced to 18 years, is all the citizens are entitled for votes. So if our government decides who is in majority and can change the constitution, if they decide that only persons who pays income tax or who are only graduates, and in that case they can amend the constitution and there is no limitation on them. So there were so many examples like this were given. Suppose that government decide that now they are not effectively carrying on the government, and if they decide to hand over this rule to the Mughal emperor or to the British emperor again, so can they be allowed to do that? So these cannot be done by government which is in majority. So these are the implied restrictions imposed on them. So The Supreme Court on 24th of April 1973, which is date of birth of Sachin Tendulkar also, gave a judgment with a majority of 7:6. The uh, judgment of Justice H.R. Khanna made a difference in that, because of his view, this majority was there in the judgment. The Supreme Court held that supremacy of the Constitution is one of the basic structure as well as federal character, the Republican and democratic feature of the Constitution, uh, separation of powers, secular character of the Constitution, and unity and integrity of the nation. So these are few of the characters which shows that there is a basic structure doctrine, basic structure of the Constitution. So on that ground, this judgment was passed, although the facts which were in issue, whereby the issue was raised that whether Golaknath needs reconsideration. So Golaknath was overruled. Thereafter, the 24th, 25th, and 29th amendments to the Constitution were upheld, but with and Article 13(1)(c), the later part of Article 31(c), which says that and later part of later part of Article 31(c), which says, and no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy was struck down. So after this Keshwanand Bharti judgment, the government was shocked, and they were not ready to accept this judgment. So uh, this one more interesting incident happened, that election of Mrs. Gandhi was declared as void, and she was barred from contesting the elections for a period of 6 years. It was by Allahabad High Court judgment given on 12th of June 1975, which was challenged by Mrs. Gandhi by filing appeal before Supreme Court. And while this appeal was pending before Honorable Supreme Court, 39th amendment to the Constitution was also introduced, whereby the amendment was to the effect that election of the president, vice president, prime minister, and speaker of the Lok Sabha will be immune, and they cannot be challenged in any court of law. And this amendment was made with retrospective effect. That means she made herself immune by any adverse judgment, or to give the effect of the judgment which was given by Allahabad High Court. Thereafter, the government came out with Sikh Industrial Acquisition Act, whereby this Minerva Mills was acquired by the government, and the management was controlled by the government. To overcome from the judgment of Keshwanand Bharti, the Indira Gandhi government came out with uh, drastic amendments in the constitution, which were Article 31(c) was amended, whereby uh, earlier it was to give effect to Part 39A and 39B and C, but now this time it was changed to giving effect to any part of the Part 4, giving effect to any scheme given in Part 4. And Article 368 4 and 5 were also introduced. Article 368(4) was that no law formed by the government can be challenged in any court on any ground, while 368(5) was of the effect that the parliament has unlimited power to amend any part of the constitution. So when these amendments were made, These were challenged in 1980 in the case of Minerva Mills. Again, this case was contested and this case was argued by Mr. Naniya Palkhiwala for petitioners. This time, Supreme Court, this matter went to 5 judges bench, whereby Article 368.4 and 368.5 were struck down by all the judges, while Article 31C, which is related to uh, giving effect to directive principle of state policies, Justice Bhagwati was in minority view, and he gave a dissent judgment by saying that directive principle of state policies will have primacy over the fundamental rights, while all other 4 judges were of the view that fundamental right will prevail and will have primacy over the directive principle of state policies. It was held that harmony between fundamental rights and directive principle of state policy is also a basic feature of the Constitution. The Supreme Court observed while pronouncing this judgment that power to destroy is not a power to amend. The donning of a limited power cannot be, by the exercise of that power, convert the limited power into an unlimited one. So, by this was the second time when uh, Constitution was saved by the uh, hard work of Mr. Nani A. Palkhiwala. So these thereafter the various other amendments were made, and this amendment was challenged. It was by making this appellate Tribunals Act. This was Central Administrative Tribunal Act, whereby the Supreme Court held that judicial review is a basic feature of the Constitution, and whereby power of High Court under Article 226 of judicial review was taken away, but power of High Court under Article 32 and 136 was uh, kept remain. So Supreme Court held in the case of Sampath Kumar versus Union of India that as power of Supreme Court under Article 32 and 136 was intact, therefore there is no violation of basic structure doctrine, and that amendment was upheld. In L. Chandra Kumar versus Union of India, whereby the State Administrative Tribunal, Article 323 A2D and 323 B3D were inserted. And in this amendment, power of Supreme Court under Article 32 and power of High Court under Article 226 was taken away. So this was held by Honorable Supreme, and but power of Supreme Court under Article 136 by way of filing special petition was intact. But Honorable Supreme Court held that Article 32 is a fundamental right which cannot be taken away. It's a basic structure. It falls under the basic structure doctrine, and therefore the uh, power of Supreme Court under Article 32 as well as power of High Court under Article 226 cannot be taken away by any of the amendment, and because this is a basic